Dear viewers, Assalamu alaikum wa rahmatullah wa barakatuh. Welcome to a new episode of your legal advisor in UAE. What are new modifications to labor law in UAE 2024? That is what we are going to know today. Let's go. Article 54 was amended to read as follows. The Ministry of Human Resources and Emiratization shall be responsible for settling disputes between the employee and employer in two cases. The first one, if the value of the dispute doesn't exceed the amount of 50,000 dirham. The second, if the subject of the dispute is the failure of one of the parties to comply with a previous amicable settlement decision issued by the ministry between the same parties, regardless of the value of the claim. When the Ministry of Human Resources and Emiratization adjudicates the disputes before the accordance with the two previous cases, its decision is enforceable immediately after its issuance. And at the same time, any of the parties to the dispute can register case before the competent court of first instance to consider the subject of the dispute within 15 working days from the date of the notification of the decision, and the judgment issued by the court of first instance in the subject of the dispute is a final judgment, meaning that it's not be able to appeal. It should be noted here that registering a case before the court of first instance leads to the suspension of the execution of the decision issued by the ministry in the same dispute. In the event that the dispute is submitted to the Ministry of Human Resources and Emiratization and the dispute between the two parties is not resolved amicable, the ministry must refer the dispute to the competent court of the first instance to be considered in accordance with the procedures followed to consider the cases before it. Finally, it should be noted that after the lapse of 2 years from the date of termination of the employment relationship between the employee and employer, the right of register a case to claim any rights under the law in the event that they are not claiming as lapsed. Modifications to Articles 6. The fine imposed on the employer has been amended to become from 100,000 to 1 million dirhams in the event that he commits one of the following acts. Number 1, employing a worker without extracting a work permit for him from the competent authorities. Number 2, if he recruits a worker from outside of country and leave him without work. Number 3, use of work permits for purposes other than those intended for their issuance. Number 4, close the establishment or stop its activity without paying the rights to the employees. Number 5, employing an underage persons. Also, the person responsible for this underage worker, he agrees to employ him while he is under the legal age, shall be punished by imposing the said fine on him as well. Number 6, fraud on the law, by hiring unreal employees in his establishment. These were the most prominent modifications to the labor law number 33 of 2021 in the UAE. For more information or any legal consultation, Contact us on the numbers shown at the end of this video. Wassalamu alaikum wa rahmatullah wa barakatuh.